Welcome to this explainer. Today we're unpacking a moment from 1994 that literally flipped South African constitutional law on its head. We're looking at the landmark Scagell case, which is this fascinating legal battle that forced a newly democratic nation to reconcile its old, heavy-handed policing laws with a brand new constitution.
To set the stage here, I want you to imagine a scenario. Imagine this. You're just sitting in your living room, minding your own business. Suddenly, you're facing criminal charges. Why? Because you own a standard deck of playing cards? Or, maybe a pair of dice from an old Monopoly game. I mean, no way, right? How does a family game night suddenly turn you into a criminal suspect who has to defend themselves in court?
Well, for decades in South Africa, this wasn't just possible, it was perfectly legal. It was all thanks to a really sweeping, kind of terrifying presumption buried deep in the 1965 Gambling Act. Specifically, under Section 6.3. If the cops found a simple deck of cards on your property, boom. You were basically forced into a courtroom to prove your innocence. In the eyes of the law, you were presumed to be running an illegal underground casino until you could somehow convince a judge otherwise.
So here's our game plan for today. 1. The deck of cards. 2. Presumption of innocence. 3. Unconstitutional presumptions. 4. The surviving clauses. And finally, 5. The final verdict. Let's dive right in.
Section 1. The deck of cards and the raid on the Highstead Casino Club.
Now, this timeline really frames the whole historical friction of the case. We start way back in 1965 when the incredibly strict Gambling Act was passed. Fast forward to 1993, and South Africa adopts its interim constitution, officially bringing in fundamental human rights. Just a year later, in 1994, the Highstead Casino in Cape Town gets raided. The folks who got busted, Gary John Scagell and his associates, immediately realized the prosecution was going to use those draconian 1965 laws against them. So they hit pause on their criminal trial and took the whole thing straight to the Constitutional Court.
To really understand what the state was trying to do to Scagell, we have to talk about a crucial legal concept: prima facie evidence. Basically, this means evidence that's strong enough to prove a case right on the surface, unless you, the accused, actively fight back and disprove it. And the 1965 Act? It was absolutely loaded with rules that turned perfectly normal everyday things into prima facie evidence of major crimes.
Section 2. Presumption of innocence. This is where the 1993 Constitution collides with the 1965 Act.
It was basically a legal heavyweight clash. In the left corner, you've got the 1965 Gambling Act, which essentially said, hey, you're guilty until you prove you're innocent. And in the right corner, the brand new 1993 Constitution, stepping in with an absolute ironclad guarantee to a fair trial. That means you have the right to remain silent, and you are innocent until proven guilty, period. These two legal frameworks simply could not exist in the same room.
Section 3. The unconstitutional presumptions. Let's break down exactly what the Constitutional Court struck down with Sections 6.4 and 6.3.
So to get why these laws crashed and burned, we need to understand a reverse onus. In a normal, fair justice system, the state has to prove you did it, right, beyond a reasonable doubt. But a reverse onus completely flips the script. It shifts the entire burden of proof onto you, the defendant. It forces you to prove your own innocence. Let's look at how ridiculous this got with Section 6.4. Notice the trigger for this law. If a police officer was delayed, even just slightly obstructed, from entering a building, the result? Whoever was in charge of that building was automatically presumed guilty of running an illegal gambling operation. Seriously. So if you were in the backyard, had no idea the cops were at your front door, and took too long to answer, you were presumed guilty. And it was totally on you to convince the judge otherwise.
But the Constitutional Court wasn't having it. Justice O'Regan took one look at this and struck Section 6.4 down completely. Her reasoning was spot on. This law could easily end up convicting someone even if the judge had a reasonable doubt about whether they actually did anything wrong. And you just can't convict someone when there is reasonable doubt in a free democratic society.
Next, the court turned its sights to Section 6.3. We mentioned this one earlier. The trigger? Just finding playing cards, dice, or other devices. The result? Instant prima facie evidence of illegal gambling. The real-world effect here was that totally innocent people were being dragged into court, forced to hire lawyers, and forced to testify, all over a simple deck of cards. The court called this provision, quote, extraordinarily sweeping. I mean, think about it. You could be arrested and forced into a trial without a single shred of actual evidence that a crime even happened. The leap from owning Monopoly dice to running an illicit casino is massive.
But the law still forced citizens to deal with the insane costs, the time, and the social stigma of a criminal trial. So naturally, Section 6.3 got thrown out too.
Section 4, the surviving clauses. Now, here's where it gets interesting, because not everything in the Gambling Act failed the test. Sections 6.5 and 6.6 actually survived.
To get why they lived to see another day, let's look at a different legal tool, the irrebuttable presumption. Now, unlike the reverse onus, which is basically a legal trap, an irrebuttable presumption is more like a strict dictionary definition used by the law. It's a foundational rule, not just a debatable assumption that you're guilty.
For example, let's look at Section 6.6. This part of the law literally just provided a list of definitions for who is legally considered in charge of a place. It said that if you're a banker, a croupier, a doorkeeper, or even just a servant working there, you are deemed to be in control of the premises.
The applicants in the case actually tried to argue this was unfair too, but the court upheld it. Why? Because Section 6.6 is just defining the who. It doesn't let the state off the hook. The prosecution still has to do the hard work of proving, beyond a reasonable doubt, that illegal gambling actually happened. The state still carries the full burden.
The court took a similar stance with Section 6.5. This one presumed that if a gambling game was happening, it was being played for stakes, money or prizes. And the court basically said, well, yeah, the very definition of a gambling game inherently means playing for stakes. It wasn't forcing some dangerous, unfair leap of logic onto the accused, so it got to stay.
Section 5, the final verdict. Let's look at Judge O'Regan's landmark ruling and how it reshaped the landscape.
Okay, so here is the final scorecard. The court essentially took a scalpel to this law. Section 6.3, where cards equal prima facie evidence, unconstitutional, invalid. Section 6.4, where a delayed cop means you're guilty, invalid. But Section 6.5 and 6.6, which just defying the structural stuff like stakes and who's in charge, those were ruled totally valid.
Now, what did this mean for the real world? Well, the Constitutional Court made a really smart, balanced move. They decided this invalidation would apply prospectively. That means it applies to all future cases and any current cases that were still pending in the system. But, and this is key, it didn't apply to historical cases that were already finalized. They protected people's constitutional rights immediately without causing absolute chaos by opening up decades' worth of old closed convictions.
I really want to highlight this powerful quote from Justice O'Regan's judgment, because it perfectly nails the whole issue. She wrote, "The constitutional complaint lies in requiring innocent persons, against whom there is no evidence suggestive of criminal conduct at all, to come to court to defend themselves." That's really the whole shebang right there. The government, no matter how badly it wants to crack down on crime, simply cannot force you to defend yourself in court if they don't actually have concrete evidence.
So as we wrap up this explainer, I want to leave you with something to ponder. The state argued they absolutely needed these extreme laws to effectively bust underground casinos. But at what cost? Where exactly do we draw the line between giving law enforcement aggressive tools to do their jobs and protecting the fundamental, basic presumption of innocence for everyday citizens? It's a massive balancing act, and every democracy has to figure it out. Thanks so much for joining me today, and I really hope this helped you wrap your head around a truly game-changing moment in constitutional law.